Public briefing note. Mazi Nnamdi Kanu is now lecturing both the judge and the prosecutor in court on the laws and constitution of Nigeria. Very shameful indeed. Federal Government vs. Mazi Nnamdi Kanu. Federal High Court, Abuja, Honorable Justice James Omotosho. Wednesday, November 5, 2025. Kanu has no valid living or extant charge against him. None. 0. Nullity. The entire charge sheet is a legal corpse, repealed, non-existent, and unamended in open defiance of a Supreme Court order. That is not opinion. That is black-letter law. That is Section 36(12) CFR N 1999. That is the Supreme Court judgment of December 15, 2023. That is the truth the judge refused to acknowledge today. Plain English, what actually happened in court, with real exchanges. Kanu appeared in court, stood up, and represented himself. The courtroom was full, tense, and expectant. 1. Kanu, my lord, there is no charge before this court. Kanu immediately adopted his motion on notice filed on October 30, 2025, and said, "My lord, this court lacks jurisdiction. There is no charge against me that exists in any current Nigerian statute. I ask that the court strikes it out today." He requested a ruling immediately. 2. Judge refuses to rule, calls the application not final. Justice Omotosho responded, "This is not a final address. The court will take your motion at the appropriate stage." Kanu replied firmly, "Jurisdiction is taken first, my lord. Without a charge, there can be no stage." 3. Kanu reads the Supreme Court judgment aloud in court. Kanu opened the certified judgment of the Supreme Court, December 15, 2023, and read the famous paragraph of Gubra JSC. Count 15 does not exist in the body of Nigerian laws. It is unknown to our law. The prosecution must amend it. He looked directly at the prosecution bench. You were ordered to amend it. You disobeyed. Yet you forced me to plead to a count that does not exist. That alone nullifies this entire proceeding. 4. Prosecution caught flat-footed, no law cited. Kanu turned to Awamalo, SAN. Learned Silk, please tell this court the extant written law I allegedly broke. Awamalo SAN paused, shuffled his papers, and remained silent. The court gallery murmured. Kanu repeated slowly. Just one law. The name, section, and statute in force today. Still no answer. 5. Kanu invokes Section 36(12), the constitutional kill switch. Kanu. Section 36(12) is clear. No person shall be tried or convicted for any offense not defined in a written law. No written law equals no offense equals no charge equals no trial equals no detention. I should not be here, my lord. Judge Omotosho replied. That provision applies at the point of conviction, not trial. Kanu shot back instantly. My lord, respectfully, that is wrong. The moment the law dies, jurisdiction dies. The trial cannot begin. It is a nullity ab initio. 6. Kanu cites global case law. Kanu raised his voice slightly and cited Lord Camden's historic ruling in Intik v. Carrington, 1765. If the offense is not found in our law books, it is not law. He added. My lord must take judicial notice of the repeal. That is the Evidence Act, Section 122. Judge did not respond to the legal point. 7. Court tries to force defense to begin. Justice Omotosho. Mr. Kanu, are you ready to open your defense or not? Kanu. I will open my defense now, this minute, if you show me the extant law under which I am charged. Court fell silent. 8. Awamalo SAN attempts an attack, and fails. Awamalo SAN rose. He is wasting the time of the court. He should proceed to his defense. Kanu faced him squarely. Senior advocate, you accuse me of wasting time? Produce the law. If you show it to me, I will enter the dock this second. Let the world hear it. Awamalo Asayan sat down. Silent. Observers whisper, checkmate. 9. Kanu accuses the court of denying fair hearing. Kanu. This is constructive denial of fair hearing. You refuse to acknowledge the repeal of the law, refuse to obey the Supreme Court, refuse judicial notice. That is persecution, not a trial. Court did not challenge the statement. Adjournment. The court adjourned to Wednesday, November 5, 2025. For Kanu to enter defense or waive it. Kanu maintained his position, no law, no trial. The charge sheet, official autopsy. Count law cited status of law legal verdict. 1-6 Terrorism Prevention Amendment Act 2013 repealed by TPPA 2022, Section 97 void. 7. Criminal Code Cap C-45 plus SEMA Cap C-45 does not exist, Supreme Court ordered amendment, ignored, SEMA repealed 2023 nullity. No amendment. No living law. No jurisdiction. No trial. The law, no legalese. Section 36(12) CFRN. If the offense is not written in a valid law, no court can try you. Aoko vs. Fagbemi, 1961. Trying or convicting under a non-existent law equals injustice. Gubra vs. University of Maiduguri, 1986. Jurisdiction comes first. Without it, the entire trial collapses. Today's takeaway, in one truthful line. Kanu proved the charge is dead. The court proved it does not want to admit it. Our demand, non-negotiable. Obey the Supreme Court, amend the charge or strike it out. Respect Section 36(12) no law equals immediate release. End the charade. Free Mazi Nnamdi Kanu now. Issued by Onyedikachi Ifedi, ESQ. Counsel and Public Briefing Lead. Abuja, Nigeria. Compiled from direct courtroom observations, verified press reports, and real-time updates.
Does not exist. The law that I have contravened. Yes. You cannot ask me to enter a defense for a law that does not exist. And particularly, the law that the Supreme Court itself has declared non-existent. So what will I be defending? We're in a country where our laws are written. This is not England where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code. They didn't make it. So, honorable, you will make that law. It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that Mazi Nnamdi Kanu is completely right and within Section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged in a court with a law that is in existence, not with a law that is not existent. Thank you. Thank you.